Good morning. We'll call the Committee on Commerce, Consumer Protection, almost said, and Health. That was last year's committee. This is the Committee on Commerce and Consumer Protection. Welcome everyone to our inaugural hearing of the 2021 session. We have a number of very interesting items on our agenda. So members, if it's all right with you, we'll go right straight into our first bill, which is Senate Bill 27, relating to home buyer assistance. Establishes the state mortgage insurance program to guarantee up to 15% of the principal balance of real property loans under certain conditions. So our first testifier is from HHFDC, Denise Iseri Matsubara, and we also have one of her staff members available for questions. And we have Denise's written testimony. Would you like to elaborate?
Just a little.
Please proceed.
Thank you. Good morning, Chair Baker, members of the committee, Denise Matsubara, HHFDC. We respectfully oppose this measure, having the state assume the risk on a new program to be administered by HHFDC. HHFDC does not have the capacity nor the resources to administer the program. It will require a general fund appropriation of seed money for the deposit into a special fund in the first year. And it would take a minimum of 2 to 3 years to start up a new program, including identifying and selecting private banking partners, entering into contractual relationships, hiring and training staff to administer, provided an exception is even granted by the administration to hire, and promulgating program administrative rules. Thank you for the opportunity to voice our concerns.
Thanks, Denise. Our next testifier is the Hawaii Credit Union League, Stephanie Sakamoto, submitted written testimony only. And our third testifier is Brent Kulbris, also submitted written testimony, and he is in opposition. So I believe those are all the testifiers we have. Before we move on to the next bill, I want to acknowledge that we're being joined remotely by Vice Chair Senator Chang and by Senator Favela. And in the hearing room with me is Senator Clarence Nishihara, Senator Bonnet Misalucha, and Senator Joy San Buenaventura. So thank you all for being here. And I think I see Senator Riviera on the Zoom as well. Thanks, Senator, for joining us. So members, any questions on the first measure, or shall we go to the next?
Just a quick question.
Senator Misalucha.
Ms. Matsubara, so I appreciate the fact that you had concerns about our budget constraints, but if monies were available, conceptually, would you support this bill?
I think even if funds were available, the time to establish it and also the time to hire, we're not sure that we would even be granted an exception to the hiring freeze to get positions. It would require a minimum of 2 more positions. I think the time is now that this type of program is needed, and my understanding is that there are programs that already exist to help first-time home buyers, such as the FHA, Fannie Mae programs. So by the time the program is actually able to even get started, we may be out of this period of dire need.
Okay.
Thank you, Chair.
Thank you. Thank you, Chair.
Thank you, Denise. Denise, maybe you could share with the committee offline some of the outreach efforts that you make to try to help people get into homes, and provide us with just a brief summary of some of the things that HHFDC is doing.
Sure, will do, Chair.
Okay. Any other questions for any of our testifiers on Senate Bill 27? If not, members, shall we move forward to Senate Bill 162? This measure relates to the Landlord-Tenant Code, specifies that the amount of damages recoverable by a tenant subjected to an unlawful retaliatory eviction is equal to 2 months' rent. First testifier is Mr. Stephen Levins from DCCA Office of Consumer Protection.
Good morning.
Good morning.
We're in support of this bill. Essentially, landlords shouldn't be retaliating against tenants for exercising their lawful rights in a way of a retaliatory eviction. The 2 months rent here for a measure of damages is modeled after an existing provision in the landlord-tenant code for, when a tenant is locked out. So there is it's not just taken out of thin air. It really makes sense. So for that reason, we're in support. Thank you.
Okay, thanks, Mr. Levins. We also have testimony in support from Imua Alliance. We have testimony in opposition from the Hawaii State Bar Association and Korea. Both of these are not on Zoom. And we have written comments from David Shi. Members, are there any questions for Mr. Levins? If not, shall we move forward? Okay. Thank you, Stephen, for being with us. We appreciate it. Our next, he's going to be back. Our next bill before us is Senate Bill 35. This is relating to also the Residential Landlord-Tenant Code, would prohibit landlords from recovering possession of a dwelling unit from tenants if habitability of the premises is significantly impaired. Sets a tenant's liability for rent if habitability of the premises is significantly impaired, and provides remedies for retaliatory evictions. Our first testifier is Mr. Levins from DCCA.
Yes, we're also in support of this measure. It's essentially the same as the previous one, except that it also speaks in terms of the warranty of habitability. We don't want to have a situation in which a landlord doesn't maintain the premises with the motivation of getting the tenant out by turning it into essentially a slum. We want to make sure that the property is adequately maintained. So for that reason and for the other reasons that I just stated, we're in support of this.
Okay, thank you very much. We have Hawaii Association of Realtors in opposition, Imua Alliance in support, and the Hawaii State Bar Association in opposition. And one of the attorneys, Mr. David Shi, submitted some written testimony in opposition. Members, any questions for Mr. Levins?
Chair.
Yes.
Thank
Senator.
you. Okay, thank you. Mr. Levins, okay, my question is, in my district, we have a lot of squatters. And my concern is that when you go to court, that the court deems by construction a landlord-tenant possibility. Are you in agreement that in the event this measure passes, that this only applies when a landlord and tenant relationship has at least occurred with a written lease?
Well, my understanding is that it would apply in a situation in which there is a tenancy. Whether there's a written lease or not, I don't believe would be dispositive of this. It's just that under the law, if a landlord and tenant have established a tenancy, I believe it would apply.
Okay, see, that's my problem, because there are, in my district, we have a lot of houses that needs to be turned habitable, but tenants move into vacant houses, and the landowner is deemed to be, that there is deemed to be a constructive landlord-tenancy relationship. I guess my concern is the portion that prohibits a landlord from evicting these squatters where there is no actual lease. But because there was considered some kind of payment by work or by, I don't know, some kind of improvement that the court may consider a tenancy may have existed even when there is no actual lease that was entered into, the landlord would be prevented from recovering possession. In those types of situations, would you agree that this particular bill should not be applicable?
Well, that's a hard one, because you could have a situation in which, for instance, a landlord enters into an agreement with their tenant for providing services in kind instead of payment, and they take advantage of the tenant's services. And then they just, create a situation where they want to get them out. And, that, in my view, would be unfair. But I understand what your point is.
So how would you amend it so that landlords are able to evict squatters?
Yeah.
Or holdover tenants? Or holdover tenants when there is clearly a need to repair the house?
I think it becomes difficult to even define what a squatter is in certain situations. So that becomes a threshold question that, would have to be looked at.
Okay, thank you.
Okay, any other questions? If not, members, shall we?
Chair?
Yes.
Hi, this is Gil. Maybe I can ask a question, please.
Absolutely.
Okay, thank you. Thanks, Mr. Levins. I'm just curious on, who determines what is uninhabitable, and how do we avoid a whole nother can of worms of the bickering back and forth?
Well,
Is there a standard for that?
Well, ultimately, the court would make a determination as to that. For example, you could have a situation in which there's a mold situation in the unit that makes it such that you can't live there without exposing yourself to very serious health concerns, or the sewage may be overflowing. It can be anything. And ultimately, the court would make that determination.
Okay, so, and then what if there was repairs needed and the landlord were willing to come in and fix them, but the tenants just never quite allowed it to happen for one reason or another, they foiled the repairs? What would be the result then?
Well, I think in that kind of situation, the court would note that the tenant is not being cooperative, and it certainly wouldn't hold the tenant in good stead with the court.
So, and then in summary, then you think that this bill helps clarify the rights and does not create more litigation? This simplifies things, or it's the protection of the tenant that. How would you summarize what this does in the big picture? Does it really make things better, or does it create more cans of worms for speed?
Well, for instance, the 2 months measure of damage, I think, it certainly clarifies things and may, in fact, have a deterrent effect on landlords who would otherwise do whatever they can to go after a tenant for exercising their legal rights. For instance, if they are complaining about, a mold problem in the unit, or the toilet is overflowing, and, that the landlord says, enough already, I just don't want you in here. And for exercising those lawful rights, they will try to get them out. If the landlord is faced with at least 2 months damages, that may in fact have a deterrent effect and cause the landlord to pay more serious attention to the concerns of the tenant.
Okay, thank you. Thank you, Chair.
Thank you, Senator. Any other questions before we move forward? I will note for the record that this measure would go on, if we move it out of committee, goes on to judiciary who would have the opportunity to address some of the concerns that have been raised, as that is probably the appropriate committee to do that. Let's move forward to Senate Bill 52. This is relating to rent control. Prohibits landlords from increasing rent above a certain percentage over any 12-month period. Establishes provisions for rent control. Excludes certain properties from rent control. Requires a report regarding the effectiveness of rent control in the state, and then would repeal the measure on 12/31/2031. So, Mr. Levens, please.
So with this bill, we're not really taking a position on the appropriateness of rent control or not, but we have very strong concerns about putting the responsibility on the Office of Consumer Protection or DCCA to come up with a report regarding the effectiveness of the measure or the act that it's ultimately passed. We don't have the resources. We don't have the expertise. OCP is a law enforcement agency. We don't have economists here. If the legislature wants to determine whether this bill is, or the act is working for the stated purpose, OCP and DCCA is not the agency or the department to come up with a report. So that aspect we're opposed to. The other underlying merits of it, we really aren't taking a position.
Okay, thank you. We have testimony in opposition from the Hawai'i Association of Realtors. We have testimony in support from Imua Alliance. We have testimony in support from Kathy Lee, Glenn Nagao. We also have testimony in opposition from Michael Iosa, representing NIOP Hawai'i, and also from attorney David Chi. Members, any other questions for our live testifier, Mr. Levens? If not, may we move forward? All right, let's go to the next item on our agenda, which is Senate Bill 206. And this measure is relating to rental discrimination. Prohibits discrimination, including in advertisements for available rental property based on participation in a housing assistance program or requirements related to participation in housing assistance programs in real estate transactions and requirements. This measure will also go to judiciary if it comes out of our committee. We have testimony in support from Hawaii Public Housing Authority. Hakeem, is Hakeem on the?
Good morning, Chair, Vice Chair, members of the committee. Thank you for this opportunity and Happy New Year. We stand in strong support of this measure. I think it's long overdue. A lot of issues for our prospective tenant having difficulties finding a landlord that will give them a Section 8 opportunity. I think in the past there were a lot of misunderstandings. We thought that they just believe that these tenants are not a good tenant because we heard that feedback in the past. But we instituted a lease in place back in December, and we find out that even landlords that have a tenant for 5, 6, 7 years, when we offered to provide Section 8 voucher, they declined. And we heard feedback from both tenants and some landlords that they just do not want to deal with tax ramifications because we have to send them 1099. I think the bill, it just gives a fairness to anyone who's willing to pay the bill, no matter what the source is, to be able to have that opportunity. Thank you very much for this opportunity to testify.
Thank you so much. We have testimony and support from the Governor's Coordinator on Homelessness, Scott Murashige. Is Scott on the call? If not, we have testimony and support. We also have testimony and support from Hawaii State Commission on the Status of Women, Kara Parolas. Also testimony and support from Hawaii Civil Rights Commission, William Hosijo.
Morning, Chair.
Good morning. I thought that face looked familiar to me.
The HCRC stands on its written testimony and support.
Okay. You want to elaborate?
Well, in the past, we've supported similar measure. We had concerns about placement of the new protection because it's different in kind from the protections that are covered under Chapter 515. I think the purpose of the bill is to increase the inventory of Section 8 housing, and as such, it would be inappropriate to establish remedies or to provide for remedies that include things like compensatory and punitive damages, because it's not necessarily in keeping with the purpose of the legislation. So with the placement of enforcement in a direct cause of action, we support the measure.
Okay, thank you very much. We also have testimony in support from the ACLU. We have testimony in opposition from Hawaii Association of Realtors. We have testimony is there a...
Yeah, sorry. This is from Purpleman. Good morning, Chair, Vice Chair.
It's from who, please?
Yes, from the ACLU.
Oh, okay. Thanks.
Sorry.
New Hope?
Yeah, I was a little behind, sorry.
Okay, sorry, I was going fast. Please proceed.
Okay. Good morning, Chair, Vice Chair, and members of the committee. My name is Hope Purpleman. Again, I'm the Legal and Legislative Fellow at the ACLU of Hawaii. Thank you for the opportunity to testify. The ACLU of Hawaii supports this bill just with one proposed amendment to raise the maximum penalty from $500 to $5,000. There's plenty of evidence of housing discrimination based on source of income in Hawaii. All you have to do is go on common rental websites like Craigslist, search for available properties, and you'll see numerous posts that list available apartments, but with disclaimers that say Section 8 not accepted. And that's just a sample of the explicit discrimination in these cases, and even getting into the implicit. The reason this is troubling is allowing this type of discrimination renders important housing programs like Section 8 ineffective in many ways. Section 8 vouchers are supposed to allow a tenant to use a voucher to offset the cost of rent in a unit in the private housing market. And one of the main intended benefits of this type of assistance is that it makes the existing vacant housing stock affordable, as opposed to having to create new affordable units to fill the need. These types of long-term vouchers have also been proven to lead to extremely positive housing stability outcomes for families experiencing houselessness. We still have one of the worst houselessness rates in the country. Vouchers and other housing assistance programs are supposed to help fix that, but if landlords can refuse to rent to these tenants, they essentially have a veto over these programs. Voucher recipients are left with very few options for housing, if any at all, and they can lose their voucher if they can't find a home before it expires. Right now, federal law does not protect against this kind of discrimination, which is why numerous other cities and counties have already passed ordinances prohibiting this kind of behavior. And these laws are, voucher holders in these areas with these laws have already reported higher rates of success in finding an apartment. This kind of discrimination should not be allowed to continue in Hawaii, and for these reasons, the ACLU of Hawaii strongly supports this measure. Thank you for your time. I'm happy to answer any questions.
Thanks, Hope. Appreciate it. Let me run through the other lists. I don't think anybody else is on our Zoom chat, and we'll entertain questions at that time. We have Rainbow Family 808 in support, LGBT Caucus of the Democratic Party of Hawaii in support, Imua Alliance support, Alani Bakal in support, and Kathy Lee in support. Members, are there any questions for the testifiers that are on our Zoom today? Any questions? If not, shall we move forward to the next bill? And it may be our last bill. Let's see. Yes, it is. Senate Bill 563. This measure is relating to commercial tenant protection. Goes forward from our committee to JDC if we move it out. And it prohibits a commercial landlord from initiating or continuing any action to evict or collect unpaid rent from a commercial tenant that has been adversely impacted by the economic effects of COVID-19 or official measures that intend to mitigate the spread of COVID-19 and would sunset in a year, 7/1/2022. So let's see, we have testimony, basically comments from the Pacific Island Institute. Andrew Lockwood noted in his testimony that we should make sure to assist small business landlords, not just the big landlords. We have testimony in opposition from BOMA Hawai'i. This is an association of owners and managers of properties, business properties. We have opposition from Hawaii Bankers Association. Neil, are you on the call? On the Zoom?
Yes, I am.
Would you like to testify, please?
Yes, I'm very short. I think our basic opposition is that there's a lot of mitigation efforts ongoing with respect to landlords and tenants, and that's evidenced by the Pacific Business News article it came out last Friday, and they did a commercial rent survey. And while we recognize that there is hardship going on, we think that the better approach is to move forward with some efforts to mitigate the situation between the landlord and the tenant. The rental assistance has included, according to the survey, rent restructure, rent reduction, and rent deferral, and about 26% in the fourth quarter was rent deferral. And I think the biggest issue we have with remedies is that it allows a tenant to terminate the lease, and that's going far beyond the stretch, I think. So those are my basic comments. Thank you, Chair.
Okay. Any questions from members on this measure? Do we have some additional testimony? Okay, we have a list of 11 individuals in support of this measure. Allison?
563.
Yeah, okay. We have late testimony with some comments from Tina Yamaki, Retail Merchants of Hawaii. She concludes with, we do believe that landlords and tenants need to continue to be encouraged to negotiate their commercial lease rent agreements and find an agreeable solution. We also recognize that many of the commercial landlords are local families and not part of big corporations. Landlords also have mortgages and other operational expenses who do not go away just because of the pandemic. Yes, we all still need to pay our rent. We also have comments in opposition from James Kimo Falconer, concerned that the bill should limit who it's intended to target by creating a minimum size of property that be affected, such as hotels less than 50 rooms, commercial rentals less than 10 retail stores. We have late testimony in opposition from Kathy Shigatori. She says this is her total opposition to the above bill. She says our commercial real estate market will self-adjust as it always has through mutual landlord-tenant negotiations. She doesn't think that they need government assistance. Alexander Peach, also in total opposition to the measure, some similar comments. We have testimony from the Hawaii Lodging and Tourism Association from their CEO, Mufi Hanneman. Says that, just wanted to comment, we understand and appreciate the intent of this measure to assist a wide variety of local businesses, but we have several concerns regarding loopholes that could be taken advantage of improperly. We have testimony in support from Becky Gardner, and she's a member of the Kamiki Neighborhood Board, and they unanimously passed a resolution in August of 2020 on this very matter. So she wanted to add her voice We also have testimony in opposition from Erin Mitsuyoshi. She thinks that the bill is a knee-jerk reaction to a long-term problem that's been created over the years. We have testimony in support from Erica Diaz. She supports 563 because it is needed to protect small businesses in Hawaii because of the impacts of COVID, which is, of course, the purpose of the measure. And we have testimony from Kamakani Ali'i, their general manager, Stephanie England, opposing the measure. Members, we will make all of that testimony available to you. It came in late.
Sorry, there's one more person. Mark.
Who?
Mark. You just should be at the end of this. Mark, so he's here.
Okay, we do have one other live person, I'm told. Well, actually, I show maybe two. Mark Hagedorn, are you on the Zoom call? Mark? Do we have David Arakawa? Land use
I'm on the Zoom call. I'm on the Zoom call.
Who is that?
Mark Hagedorn.
Great, Mark. Please proceed with your testimony or your comments.
Very good. Thank you so much. This is an amazing process.
Yes, it is.
At this stage. Honorable Senators and CPN committee members, it's my honor and my privilege to speak with you this morning. I'm a small businessman and leaseor, leasing space to several commercial leases, leasees in Kaimaki Business District. My neighborhood in Kaimaki is filled with leaseors, leasee, small business operators. I've been both a leaseor and leasee many times throughout my business career. I'm a member of the Kaimaki Business and Professional Association, and I've served in the Kaimaki Neighborhood Board as both an officer and also a member for 4 years. And I know our community members, and I know the business of our community. Many of our small business owners in Kaimaki and throughout Oahu rely on lease rental income from our leases. When times are hard, we use this rental money to pay our mortgages, our property managers, our employees, our building maintenance, fiscal managers, taxes, and yes, our ohana. They're all looking at us to continue to pay each month the mortgages, the management fees, the maintenance fees, and property taxes for our community. We work together with our tenants. We exercise forbearance when necessary. We negotiate lower rents or shorter lease periods. And most importantly, we do not need government control in our back pockets. We've already been doing this for the past year. Please don't take negotiation tools away from the leasees or the leaseors by attempting to pass a law that treats all situations as if they were equivalent, or worse, as if they were part of the mainland. If you cut the supply of cash flow from the lease rentals, you'll be cutting the cash flow to the leaseors who owe the bankers, who own the mortgages, to the property managers, the real estate professionals who service the properties, the city and county officials trying to collect property taxes, and the state government trying to collect general excise taxes. So in summary, there's no one deep pocket in this situation. We're all in this together in Hawaii, and together we're capable of working through this situation without further legislation. Let business community do what they do the best, which is negotiate in the best interest of the community. And I really want to thank you for, under the circumstances, for allowing our community time to express their opinions. This is a very unusual format. And I want to thank you for your hard work serving the people of Hawaii. I want to take the time to do that. Thank you.
Thank you so much. We also have Kapolei Hawaii Property Company LLC in opposition and Melissa Bowe in support. Did I miss anybody?
There's William Moore on this.
I'm sorry?
William Moore as well.
And, okay.
Yes, he's leading Importers LLC.
He's what?
Leading Importers LLC.
Okay. I think I skipped over somebody else who's joined us on Zoom, so we want to go back and make sure that we catch everybody. My crack staff is on top of it. I believe we have William Moore, Leading Importers LLC, on the Zoom. Mr. Moore,
Yes, I'm here.
would you like to provide the committee with your testimony?
Yes, thank you. I cannot speak on behalf of other tenants, of other commercial leaseholders in Hawaii. My situation is unique to me, but maybe it's a good balance between the previous person that spoke of small leaseholders renting from small landowners or small lessees and small lessors. I'm not in that situation. I lease my property from the Howard Hughes Corporation. I think it's important to give some framework that in March of last year, right when COVID was hitting, the Howard Hughes Corporation lost, their stock price fell from about $135 to $35. The chairman of the board of the Howard Hughes Corporation during the very first weeks of COVID, purchased 10 million shares at the lower price, a profit of about $370 million. My business is closed. I've never missed a rent payment. I'm still paying rent. I've lost $260,000 so far. I still have $100,000 worth of rent left to pay. I've negotiated for months with the Howard Hughes Corporation, but mostly they just won't return my phone calls and emails, only with lawyers. That they finally came back and made me an offer to terminate my lease early. They said that if I pay 95% of my remaining rent, then they'll terminate my lease early, and then they'll rent out the place again and collect double rent. So if the state doesn't step in, and not only for me, for others, I can't speak for anybody, but my situation's already done. My business is lost. I can't do anything. But if the state doesn't step in and stop these huge corporations from not only profiting on one end, but profiting on the other end too, on the backs of people like me, what other recourse do we have? I come here today with everything already lost. I don't come here today to try to save anything. So that's my testimony.
Thank you very much. We appreciate you taking time to share your perspective with us. It's very helpful. Members, any questions for any of the folks on Zoom?
I have a question.
Senator
sorry.
San Buenaventura?
So, my question is really with Hawaii Bankers Association. Is there any banker in Zoom? No.
Yes, not a banker, but I'm with the Hawaii Bankers Association.
Okay, may I speak to the Hawaii Bankers Association?
Okay, this is Neil.
Hi, Neil Okabayashi.
Right.
Okay, so here's my question. Now, when we had the emergency proclamation, there was a moratorium on residential evictions, but there was also a moratorium against foreclosures. So if we pass this bill, what I want to know is, could there also be a moratorium on foreclosure so that the small landlord like Mr. Hagedorn won't be foreclosed on in the event they're not getting any rent? Is there some kind of protection for a small landlord?
I believe that is part of the bill. It provides for a moratorium on all landlords.
No, but what about foreclosures? I mean, not landlords, but foreclosures on the property owners who cannot now pay their mortgage because they're not getting any rent, because we're not allowing them to evict during this period, during this moratorium. Because I remember on the residential level, FNMA, Fannie Mae was prevented by federal law from foreclosing, which then helps the landowner who is then prevented from evicting, right? There was an eviction moratorium for residents. But I want to know about commercial. Is there also a moratorium on foreclosures? And so
on the federal level, there isn't, but there's a practical consideration, although I don't do any litigation. My friends in the litigation loss sector tell me that the courts are so clogged, and, you know, priority has to be given by the courts to criminal cases, that civil cases such as foreclosures are somewhat backlogged. You've seen how backlogged it is by the prosecutor in Honolulu, seeking some relief on DUI cases, but trying to enter into some sort of an agreement, a plea bargain. But I think that, at least for the Hawaii banks, they've tried to work with landlords to ameliorate the situation. One bank said, and this is public, it's in their second quarter, I believe as part of the SEC statement, they reported that they had about 1.1 billion in concessions in the commercial sector. Not all of it goes to commercial landlords, but part of it does go to commercial landlords. Because one of the things for a bank is you don't want to foreclose on somebody, and because what are you going to do with that property? The last thing banks want to do is take someone's property, because then they have to own it, manage it, and then try to sell it. And in this environment, that's not going to work. So what you really try to do is to work with the landlord and see, what can you pay?
Okay, so what I just want to know is, shouldn't this bill be amended to protect the landowner from being foreclosed on only in the event that they are unable to make their mortgage payments because they cannot evict the commercial tenant? Because otherwise, we're just depending upon whether or not the courts are clogged, right?
No, I would not agree to that. I think the answer is, as has been done, is mitigation attempts between the tenant and the landlord, and between the landlord and the lender.
Okay, thank you.
Besides, I don't think the title of this measure would accommodate what you want it to do.
Okay, sounds good.
Any other questions or concerns? Members, I believe this brings us to the end of our agenda. With your permission, let's take a brief recess and see if we can accomplish some decision-making this morning. So let's take a recess. Okay, we will reconvene the Committee on Commerce and Consumer Protection for purposes of decision-making. Thank you all, members, for joining us today. On Senate Bill 27, the recommendation is that we defer this measure. When we heard a similar bill, HOU was lead on it and deferred it, so we're going to be consistent in that regard. Any concerns, comments? Senate Bill 162 relating to the Landlord-Tenant Code. Chair recommends that we pass this measure with amendments suggested by Mr. David Chi. Any questions or comments? If not, Chair votes aye.
Senator Chang.
Aye.
Senator Misalucha.
Aye.
Nishihara goes aye. Senator Revere.
Aye.
Senator San Buenaventura.
Aye.
And Senator Favela. Aye. Okay, motion's adopted.
Thank you, members. The next measure is Senate Bill 35. This is also relating to Landlord-Tenant Code. It goes from our committee to JDC, and the recommendation is to pass with amendments, basically defecting the date and asking JDC to take another look at the measure. So the defective date 7/1/21-24. It'll be a very good year. Any questions or comments? If not, Senator Nishihara, chair votes aye.
Okay. Senator Chang,
Aye.
Senator Misalucha,
Aye.
Nishihara goes aye. Senator Revere,
Aye.
Senator San Buenaventura,
Reservations.
okay. Senator Favela. Motion is adopted.
Thank you. The next item on our agenda is Senate Bill 52 relating to rent control. Chair recommends that because of all of the concerns and opposition that was raised, that we defer this measure indefinitely. Any questions or concerns, comments? If not, let's move forward to Senate Bill 206 relating to rental discrimination. This prohibits discrimination, including in advertising for available real property based on participation in a housing assistance program or requirements related to participation in housing assistance programs and real estate transactions and retirements. Chair recommends that we pass this measure with amendments. There are some technical, non-substantive amendments identified by SMA. Add to the findings and purpose the language recommended by the Hawaii State Commission on the Status of Women and a fine not to exceed $5,000 instead of $500. Any questions, comments? If not, chair votes aye.
Senator Chang,
Aye.
Senator Misalucha,
Aye.
Nishihara goes aye. Senator Revere,
Aye.
Senator San Buenaventura,
Aye.
Senator Favela. Senator Favela. Thank you. Motion is adopted.
Thank you, members. Senate Bill 563 is the last item on this morning's agenda. This one, if we pass it out, should go on to JDC. This has to do with commercial tenant protection, prohibits a commercial landlord from initiating or continuing any action to evict, collect unpaid rent from a commercial tenant that has been adversely impacted by the economic effects of COVID-19. It sunsets 7/1/2022, so it's short term. Chair recommends that we pass with amendments. We'll take the tech and non-substantive amendments identified by SMA, take the Hawaii Bankers Amendment to delete the phrase pursuant to this subsection regarding termination of a lease. So it's not just this one, it's the entire section regarding termination of leases. And include a definition of impacted commercial tenant to include the commercial tenant has applied for a paycheck protection program in the calendar year 20 and 2021. And change language on page 5, line 5, from 20% to 25% to be consistent with the paycheck protection program requirements for a second paycheck protection loan. Is there any questions? Okay, if not, chair votes aye.
Senator Chang,
Aye.
Senator Misalucha,
Reservations.
Nishihara goes aye. Senator Revere,
Reservations.
Senator San Buenaventura,
Reservations.
Senator Favela.
Reservation.
Okay, motion is adopted.
Okay, thank you, members. I believe that brings us to the end of our agenda. Thank you so much. Enjoy the rest of your day, and I think we have another hearing coming up tomorrow.
Okay.
Very good. We'll see you all then. We're adjourned. Thank you.